So, hello, my name is Professor Stephanie Richard, and I'm the director of the Sunita Jain Anti-Trafficking Initiative. I want to thank you all for your collaboration and support in joining this training on a very important issue that's been really underutilized in California, but is so important to trafficking survivors' full recovery from their victimization. And so this webinar will be an in-depth discussion and training on looking at aspects of human trafficking for forced criminality, as well as how do we as attorneys apply for the specialized vacatur for human trafficking victims under California Penal Code 236.14. We'll briefly discuss how to apply for domestic violence and sexual violence survivors because the standards are very similar. So let's get started. So as I said, I work at the Sunita Jain Anti-Trafficking Initiative, and we are an evidence-based, community-informed think tank that's really practitioner-led, and we focus on policies that prevent trafficking before it starts and increasing access to services. Our policies all focus on non-carceral approaches to anti-trafficking because we've seen the anti-trafficking movement focus for too long on carceral solutions to ending trafficking, which we know we cannot prosecute or arrest our way out of this problem. And what we see in taking that approach is that many survivors, as part of their victimization, and because of the focus on the carceral system, need assistance from lawyers to remove criminal records that are part of their victimization. And I put in the chat, if you're interested, Sunita Jain initiative's approach around restorative justice and human trafficking. It's a letter of support that you can sign on for a $25 million budget request. We believe until we have alternatives for accountability, we will not be able to move our system from a carceral approach, especially with regard to trafficking. So because I know advocates on this call are likely to support something like that, I wanted to put a plug in and put it in the chat. And that will be all the policy we talk about. Now we're going to get to the direct services. So again, my background is in direct services. I've worked on anti-trafficking efforts for 20 years in California. I used to supervise the largest legal services program in the country for trafficking survivors, helping survivors navigate complex immigration, criminal, and civil remedies. As well, I used to oversee the National Technical Assistance and Training program funded by the Department of Justice for all other attorneys working on trafficking in the US. And we would field calls around mainly immigration and criminal convictions. And so have a depth of experience from that nationwide work. And then my organization, the Coalition to Abolish Slavery and Trafficking, was the original sponsor of the original vacatur bill around Penal Code 236.14 that was passed in 2016 and went into effect in 2017. So I have deep expertise also in looking at, well, how do we effectively implement this relatively complicated vacatur provision? I'm not going to have you guys take this poll, but I wanted just to see, to see how much time I should spend on the part that kind of gives a brief overview on trafficking. How many of you have ever attended a training on human trafficking where you really are looking at the legal standard, not just a general training on trafficking? If you can raise your hand or just put in the chat if you have done that kind of training, that would be helpful for me to know. And then the other thing I wanted to know that you can put in the chat or just raise your hand is if you've provided any kind of direct legal services directly to human trafficking survivors. Okay. I'm not seeing anything happen, so I'm going to go on and just assume that it's good for me to always cover a background on human trafficking. And the reason I'm doing that is that the framework for the vacatur, the most important thing to assess is if someone is a victim of human trafficking to begin with. So we're going to just start with the basic legal standards around human trafficking. So I like to start by saying at its baseline, and when I'm explaining what human trafficking is to lay people, that human trafficking at its core is about exploitation for commercial purposes, and that individuals don't choose if they're sex or labor trafficked or both. And in this context, I also want to say that they don't choose if they are forced to commit crimes by their traffickers as their form of labor or services. And what we see if you're a practitioner that works with both sex and labor trafficking survivors is how individuals are recruited into trafficking and the dynamics and complexities of the relationship between a survivor and the trafficker are very, very similar. And so when we're identifying trafficking cases, we can generally use the same types of targeted specific questions to help identify all types of trafficking victims. But I think too often we're only asking these questions for sex trafficking victims. Now, the framework that started to address human trafficking comprehensively in the United States started with the passage of the Trafficking Victims Protection Act in 2000. And this was the law that created the definition of, of crimes that were specific to human trafficking in the modern day. It also created the access to immigration benefits, and for the first time, the federal government funded specialized services to organizations working on trafficking in the United States. Um, and then in subsequent reauthorizations, these laws were updated. It's important to note that at the federal level, there is no equivalent vacatur standard, despite survivors and advocates asking the federal government to adopt such a standard, given the dynamics of trafficking for the last 10 years. The probably the most important definition that I want people to have looked at and thought about when you're looking at trafficking as lawyers is the definition under our federal law of who is a victim of human trafficking. And so our federal law defines that person as someone who's a victim as a severe form of trafficking in persons means sex trafficking in which a commercial sex act is induced by force, fraud, or coercion, or which the person induced to perform such an act has not attained 18 years of age, or the recruitment, harboring, transportation, provision, or obtaining of a person for labor or services through the use of force, fraud, or coercion for the purpose of subjugation to involuntary servitude, peonage, debt bondage, or slavery. And I always read this definition out loud because this is the reason why so often I think that people are not appropriately identifying all victims of human trafficking because it gets lost in this language. And so I like to point out a couple of facts. So the first is even though our federal definition requires and defines severe form of trafficking, severe for us attorneys just means you meet the A or B definition. So you can be trafficked for just a day, you can have no physical violence, and you meet the definition of victimization. This issue is not as large an issue when I first started my career, but I do like to point out that that severe is all types of trafficking are severe. Okay. And then the other thing that I'm sure if you've received a training on human trafficking before, you've seen is that this very complicated definition of who is a victim of human trafficking is broken down into three elements: process, means, and ends. And when I'm looking at identifying a trafficking case, I like to start with the end result. As I told you at the beginning, the thing that distinguishes trafficking from any other crime is the fact that uh, it is for commercial sex or labor or services. So if you do not have either of those elements, then you do not have a trafficking case or person who's been victimized in that way. And so you should start there just to make sure that there's some kind of commercial element involved, because I can't tell you how many times people have come to me with cases that have red flags for trafficking, but really the facts that they show just meet the standard for kidnapping or or rape, and you need that commercial element, and those are things that you need to ask your client about specifically. So once I've determined that there's some kind of commercial element, I then want to look under the definition for what is the means, because trafficking requires force or fraud or coercion. And I want to note that for adults who are sex trafficked and minors and adults who are labor trafficked, that is the standard that's required. However, for sex trafficking in a minor situation, you only need to show that they were induced into commercial sex. And that's important to understand because for minor victims of trafficking, that means that you can be a trafficking victim when there's no third party exploiter commercially benefiting, and that the exploiter is actually the purchaser of commercial sex in that case. But for all other categories, you need that force, fraud, or coercion, and we will talk very specifically about what those definitions mean and the types of questions we should ask to elicit that information. And then I find that the process is pretty easy to determine once you found the end and the means, and it really just shows that you can be trafficked here in Los Angeles, never leave Los Angeles, and still be a victim of trafficking under both our federal and state definition. So one of the misnomers about trafficking is somehow that you have to have transportation. But as you can see in the definition, recruiting, harboring, transportation, obtaining, or providing a person are common. So just as long as you're utilizing someone for commercial sex or forced labor, you have the victimization required. I started with a federal definition, but I know we're talking about California state law, so I just wanted to point out that California state law was created by AB 22 at Penal and then Penal Code 236.1. It has that same dynamic where it looks at sex and labor trafficking, and we also have a lower standard for minors of sex trafficking who do not have to show force, fraud, or coercion. Our our definition of trafficking is really muddled and has lots of verbiage in it, which is why I like to start with our federal definition, which is a little bit cleaner. But I just want, and also because my own assessment and the language of the statute says this clearly that the California definition is equivalent to the federal definition. But I just wanted you to see that under our California definition, the force, fraud, and coercion standard is slightly more complicated to be force, fear, fraud, deceit, coercion, violence, duress, menace, or threat of a lawful injury. And I think what's most important to know about our state definition is it says per se, if your passport or identity document is taken, then if it makes you work or engage in commercial sex, that is trafficking. So that's slightly broader than our federal definition. And then we have this interesting deprive or violate the personal liberty of another as our process. And there's very limited case law on this, but basically, again, if you find recruit, harbor, transport elements that you see in our federal law, it will be the equivalent. The only debate is because timing, like would one day in trafficking be enough given the standard here? But again, there's no case law that interprets that. And you have the same pattern that you're looking for under our state law, which is that the end result has to be for commercial sex or labor or services. Again, there's lots of guidance out there on how to identify trafficking cases, but this new guidance came out from CAST that I really think is a great checklist. And so I put a slide on it here in case you're someone who likes check the boxes. And this is there's even a blank one then that you can fill out as you're doing your cases. So these are the next most important definitions when we're talking about human trafficking and eligibility for benefits like vacatur. So is that force, fraud, and coercion element that's required for everyone but minor sex trafficking victims. So I want to note that it's an or standard. So if you have any of these three things, you can show that someone is eligible for vacatur and other benefits as a trafficking victim. So the first thing is that threats of serious harm to or physical restraint against a person are enough. So what that means is you don't have to have physical violence or physical restraint, the force. That is one of the things that you can have to show trafficking. And the majority of cases, a lot of times won't have the physical violence or physical restraint, but they'll have the threat of it. Okay. The next thing that you can have is abuse or threatened abuse of the law or legal process. Again, a reminder that's an or, so it can be just if someone is threatening you to call ICE, call the police and tell them that you stole something, take away your children, um, make sure that you lose your immigration status. Okay. And then the last thing is why we as attorneys are really needed to identify trafficking cases so often because it's a really broad standard that's any scheme, plan, or pattern intended to cause a person to believe that failure to act would result in serious harm or physical restraint. Okay, so that's a mouthful, but we'll look at what does serious harm or physical restraint mean. But the plan or practice, it really shows that like it can be a wide range of things that traffickers use to manipulate someone to get them, right, to labor or engage in commercial sex. And we've seen that. And so we'll talk a little bit more. And I just want to note that these definitions I'm covering are both in California Penal Code 236.1 as well as under our federal definition. Um, so we talked a little bit about abuse of legal process, and although our California code doesn't provide a more detailed definition, federal law in 2008 provided clarifying information. So it really shows how broad these threats can be. It's use or threatened use of law or legal process, whether it's administrative, civil, or criminal, in any manner or for any purpose for which the law was not designed, to exert pressure on another person or to refrain them to cause or have them refrain from taking action. So basically, that they stay in the forced labor or commercial sexual exploitative experience. The next really important definition that also isn't in our California Penal Code 236.1, but was in our federal definition in the 2008 update, is this definition of serious harm that you see under that scheme or plan, right? And then also the threats. And so what I want people to realize is that that harm, it can be physical, psychological, financial, or reputational by definition. Okay, so it doesn't just have to be physical violence or physical restraint, which is, I think, the way a lot of people interpret it. And then it has an even more qualifying standard that says it has just must be sufficiently serious under all the surrounding circumstances, so taking everything into account, to compel a reasonable person of the same background and same circumstances for labor or commercial sex to avoid harm. Okay. And again, that harm is physical, psychological, financial, or reputational. And so again, we have to remember that, like, for example, immigrant survivors who maybe don't know the rules or language in our country will be held to a lower standard than, say, a college educated lawyer, or a child is going to be held to a different standard at different ages than an adult under the definitive definition. And so when we're creating our cases, we want to make sure that we're eliciting facts that show these kinds of serious harm. The last thing I'll cover before we get into some of the dynamics around human trafficking for forced criminality really quickly are just common myths around trafficking. So we already talked about how trafficking does not require movement. The other thing I like to highlight, especially in vacatur cases, is you cannot consent to an illegal act, meaning you cannot consent and be complicit in your own trafficking. So you might have agreed initially to work in commercial sex and or carry drugs because you thought you would benefit. But as soon as force, fraud, or coercion is used against you, that action switches from voluntary action to trafficking. Okay, so trafficking can be a spectrum where sometimes it's voluntary and sometimes it's not. But again, to have trafficking, you you can just because you consent to something initially doesn't mean you can't have the victimization. I think that's really important in how we as attorneys analyze these cases, especially when we look at the standard in the vacatur context, which requires the crime to be a direct result of the trafficking. And we'll talk more about that. The last thing is that work with a lot of trafficking survivors who have received payment, sometimes above minimum wage. Okay. So I just like to remind people that getting paid doesn't necessarily mean that you're not a victim of this crime. It is not an element. And then the most common question I get in labor trafficking cases, well, what's the difference? What's the difference between labor trafficking and labor exploitation? As a lawyer, what I can tell you is if you're identified as a labor trafficking victim, you get far more protections and benefits than labor exploitation. So it's really important for us as attorneys to know those distinctions. From like a legal framework, how do we tell the difference? So for labor exploitation, what it is actions that can violate both criminal and civil labor workplace laws. And you can see extreme exploitation, no payment or absence of a living wage or long hours, poor working conditions and health and safety problems. You can see arbitrary discipline and verbal or physical abuse. You also can see types of fear and intimidation, especially if you're working to organize around a union. So just those things alone, right? They could be red flags for trafficking, are not enough. And so how do I tell people to assess? In a trafficking context, you have to have a third party who makes someone believe that they have to keep working in that labor or service or something bad's going to happen. So we know with vulnerable communities that many individuals work in environments that are bad, unsafe, and they believe it's the best they can do. They're thinking, I don't feel like I could find another job. That's why I stay, right? Whereas in the human trafficking context, what you have is a third party, the employer, the trafficker, who is making the person feel like if I don't stay, my reputation will be ruined. I will lose my home. I won't have a place to stay. I could be arrested. I could be deported. That is the difference. And so you're looking for, even if the person feels like, right, don't have any other job options, you're looking for what is that third party doing independently? And is that causing someone to stay even a day or two longer in their situation? That would mean that they rise to the level of trafficking. And I just have a couple of examples of sex and labor trafficking that I wanted to just use to ground you because they are cases also where mistakes are made. So this case was widely publicized in the news a while ago, and it was a young woman who'd run away from foster care, and she was kidnapped by two men who kept her in a locked box, and they kept sexually assaulting her and physically harming her. And she was only allowed to kind of leave this box when the men forced her to cultivate marijuana without pay. And then she ultimately was arrested on drug charges. Okay. And then when they finally saw her as a victim, they actually misidentified her as a sex trafficking victim. So I use this example because I want to be really clear that there can be sexual assault involved and it's not sex trafficking. Actually, almost 1 in 3 labor trafficking cases that involve women, we have data that shows that there is some kind of sexual assault as part of the control. The next thing I have is Angela. She's 34. She started running away at the age of 13 because of sexual abuse at home. And then she was introduced to a man who forced her to engage in commercial sex through beatings and other abuse. So clearly a victim of trafficking just under the inducement standard and because she's a minor, but also because of the physical violence. Now, what's difficult with this is that when Angela came to the service provider, she'd also been arrested at the age of 33 and charged with sex trafficking other minors. Okay, and I use this example because you'll see that vacatur can be used in this case. And then the last one is Alex. He's 14. He's from El Salvador, and he's recruited by gang members to steal gold necklaces. And while he's being forced to steal gold necklaces, he's not allowed to return home. He has to sleep in stolen vehicles. When Alex finally gets home to his family, they do call child welfare for help. Um, and then child welfare actually puts Alex in a group home, but no one ever identifies him as a victim of labor trafficking. And so when he comes back home, he actually voluntarily starts with a group of boys his own age, um, stealing cars. And when I met him, he was facing felony larceny charges. And so, in this case, this was a true missed opportunity where he could have been identified as a labor trafficking survivor, but because he didn't get the care and psychosocial education he needed, he then voluntarily started engaging in a crime that now has very serious consequences. And so the last thing that I want to talk about, just because everyone, when I train on human trafficking, wants me to talk about, well, what questions should I ask trafficking victims? And I do want to say that I never think that there's a checklist that you can ask questions about to identify trafficking as a lawyer. My own assessment is it's always best to learn about the situation and then ask specific questions based on the facts that you learn. But the general things I start with, because I feel like people can concretely talk to me about this, is, how was the person recruited? How did this start, right? And what were they told or promised? I then like to ask about things that deal with concrete facts, like, oh, was your passport or identity documents taken? Because that's a yes or no, right, question. Or did they get paid and what was it? Even though that isn't an element of trafficking, it can be a red flag if you're not getting paid. And then I like to say, well, describe like what it was like when you were working. And then from there, I'm going to ask very specific targeted questions that ask them about force used, physical threats, legal threats, and any kind of plan to control. And it's going to be based on the things they've already told me. Otherwise, it can just be too overwhelming and long a list. And so that's sort of my rule of thumb when I'm talking about how to assess an initial trafficking facts. And the last thing I just like to remind people is there's lots of bad facts that you might find and that you might have to deal with in your declarations when you're writing for legal services support. And so my first thing is always to say, do you really have to include the bad flat fact? Is it central to the case? And is it part of the legal element of the crime? All these things on this list, I don't think are central. And so, but if you do have to share it, you should explain it. Otherwise, it could make people doubt the trafficking. So if they get to keep money, if they express that they're doing this for their family or a loved one, if they express no one's making them do this, if they have bank accounts or pay stubs or have access to cell phones or cars or days off or freedom of movement, or if they come back and return to the same exploiter, or if they're living in their own home, or at a separate place than their trafficker. So again, sometimes when you're telling the trafficking story, you will have to talk about the bad facts, but your assessment should always be, is it legally necessary that I reveal that? And then if it is, uh, because I need it to tell the story, then make sure that you're presenting it in the best light possible, because these are things that, people will question you about. And my next slide really is to, remind everyone that trafficking happens in all industries and it happens where we're looking for it. But I think, as I talked about a little bit at the beginning, that the attention has been, and especially in criminal vacatur work, on assisting individuals who have been involved in commercial sex. And actually, what I think new evidence is showing and revealing is that both sex trafficking victims, but also labor trafficking victims, have been forced to engage in other types of illegal act or services that are the actual trafficking and will need the criminal vacatur we're talking about. So this is called human trafficking for forced criminality. And I'm curious if you guys can put in the chat or just like put a thumbs up, or how many of you have heard this term human trafficking for forced criminality before? And so, what's really interesting and important to remember is there's no legal definition of what that labor or service can be. So, just like working in a restaurant and agriculture can be a type of forced labor, so can recruiting others into trafficking, right? Or facilitating their trafficking. So can smuggling, selling, cultivating drugs. So can stealing cars or other types of property. So can a lot of gang involved activities, right? So can benefits fraud or scams, or magazines sales, or people who are receiving truancy tickets. All of these things, right, can be part of the result of the labor or services that someone is engaged in. And so we need to think that the criminal activities can be labor or services, and this is what we're looking for to when we're vacating cases. Um, and because it seems like a lot of you have a strong background in human trafficking, I'm not gonna play this video from Jimmy Lopez, who's lived expert and works with SJI. If you want to watch the video, it's available on SJI's website. But in this video, he really talks about being a victim of labor trafficking twice. One at a furniture shop for 2 years, where he was not identified and protected then. And then when he finally escaped on his own, running to a restaurant, and then without him knowing, being employed again and being and driving a car and transporting drugs, which then landed him in Los Padrinos for 2 years. And it was only when his public defender identified his victimization, both for the forced criminality as well as for the labor at a furniture factory, that the correct services. And what's shocking to me is that Jimmy, when I asked him for the first time, when I was presenting with him on a panel of judges, if he thought this was common, he said, "Oh, yeah, when I was in Los Padrinos, I met at least 15 or 16 other boys who I think had the same experience I did. And I don't think anyone ever identified them as victims the way I was." And so we know, in addition to our resources and services and identification focusing on sex trafficking, we also focus a lot of our identification on girls, and or our boys might be less likely to tell us about the abuse unless we're asking about it directly. So I like to highlight his story. The next thing I want to highlight with this group is something that I've been thinking deeply about. Like, how do we really distinguish in peer recruitment, teaching, facilitating, trafficking? And so I think when you have the complexity of someone crossing the line and maybe engaging in the elements of trafficking crime, you want to ask, these are the three questions I'm asking myself. Is the labor trafficking for forced criminality? So what you're looking at, is that person engaging in that trafficking behavior because force, fraud, or coercion is used by a third party? Okay. So that would be the clear case that you could have vacated. The next thing level we've seen with kids and even adults is it mutual aid? Is an individual helping another individual meet unmet needs? But that second individual is not commercially benefiting. They're just helping each other keep each other safe. That's the most complicated, I think, to assess criminal liability because, again, a lot of systems, especially if it's a minor, is going to see that person as the exploiter. Um, and even if they were assisting and not commercially benefiting from that person's direct labor or services, again, just that inducement standard might be enough. So that's going to be your hardest case to argue vacatur for. And then the cases you can't argue vacatur for, and you do see victims who become traffickers, is that an individual has moved into using force, fraud, or coercion for another individual. So even if someone has been a victim in the past, they can become a trafficker. And that distinction is really, if they start commercially benefiting from a different individual. So those are kind of the complex assessments that you're going to want to think about and make when you're assessing your vacatur petitions. Um, I am going to see if I can play this video really quickly because these are the types of cases that I think are all out there and that we're not helping enough. And if we start vacating these cases, they will become normalized as opposed to how it's portrayed now. So this video.
Sometimes they make you beat up someone, stab someone.
I've moved weed, I've moved cocaine. 2, 3 times I've gotten into houses and I know I've directly, me, myself, I've shot down like 5 people.
Well, right now, after everything I've done, you know, all the problems I've caused, I just want out. I want out of all this. But if they ever need me, I know that I have to go back.
You could get recruited at any time, by anyone, and at any age. I've moved weed, I've moved cocaine. I would teach illegals how to say U.S. citizen, or I would hide them. There's little kids that are 9, 10 years old shooting people. 2, 3 times I've gotten into houses and I know I've directly, me, myself, I've shot down like 5 people. Cold, you know. You gotta be ready to die at any moment. It is a fear of mine, but I've accepted it as an inevitability.
Yeah, I'm not going to have you watch this whole video, but I just wanted to use this to highlight there's no talk of these kids' victimization, but it's really clear if you're listening to this with a forced criminality ear that all the kids that are portrayed in this video are victims of human trafficking for forced criminality. Their victimizations often started at 11 and 12 years old, yet they're the ones facing criminal charges. The same thing, and so this is focused on our foreign national kids, but actually, and I won't play this video. It's pretty disturbing, but it's a video that involved U.S. citizen gangs, and in this video, what you see is three gang members ordering other gang members to physically assault an individual, and then when they stop, they order them again, no, keep going, or the same thing will happen to you. And so arguably, right, again, these are the kind of images where you have to think about, is this type of gang activity actually forms of victimization, and should a subgroup of those that we've been criminalizing be actually receiving the same benefits and services that crime survivors should? And my belief is they should. But again, these are the cases that you guys on the call, I think, can start arguing and educating judges about from the vacatur perspective to really change the culture. And so when we're really looking at individuals involved with gangs, we should be really important not to argue, right? That everyone involved with the gang is a trafficking victim, but my own personal opinion is a lot of them are, okay? And so how do we really, suss out and determine if we can present someone as being victim? So I think these are elements that I would assess and look at. So you want to consider the circumstances and each time period of vulnerability. So is the individual homeless, and are they acting out of necessity? Is there a third party exploiting that vulnerability? So is it that or the necessity? Kind of the same thing you're looking at the mutual aid, right? And are there time frames where it's clearly human trafficking, and then does it slip into voluntary, or vice versa? Okay. Again, then when I'm looking at the gang-related offense, I'm looking at, well, who are the real leaders of the game? Who's really commercially benefiting? How old are they in comparison to the person that I'm working with? And why was the person afraid? And how much did they commercially benefit, right? And finally, I'm going to look at the relationship between all the individuals involved. And, again, in the easiest cases and the ones we probably want to start with, it's going to be an adult involved with a child, right? And so if there's that kind of power dynamic, And I think it's much easier to establish, especially in these gang climates, who is the one commercially benefiting and how a child's being manipulated. But then you also want to look at the underlying factors because we do see generational trafficking where an adult family member and their children are trafficked together. And then also we see a lot of times where children and adults end up being involved because of a familial debt. So these are all factors to look at. And again, every case is going to require a very complex um, uh, assessment. I would say, given where we're at in people's understanding of these issues, we have to start with the most straightforward. And I can tell you, so many of my cases where if you just ask the right direct questions, it feels like it's a no-brainer and that anyone would understand the victimization. So those are the cases we should start with and then move on to maybe the more complicated ones. And so, what are common examples we see of forced criminality in gangs? You have an adult gang leader who orders a youth to transport drugs, carry weapons, or commit violent acts against rival gang members and threatens them with physical violence or serious harm if they refuse. You see examples of an older adult family member coercing a youth to participate in a drug trafficking ring or join a gang other family members are associated with. Those are sometimes the most complicated cases because of the family dynamics, but usually the coercion is pretty clear, and especially if the child's pretty young. And then we've also seen cases where you have like a drug dealer who says that they'll erase the family's overall debt if the youth commits some other kind of crime. So again, the reality of human trafficking involving gangs is it involves all the types of crimes that we list for human trafficking for forced criminality, and that you just have this complicating factor of showing, right, that that person is not the gang member commercially benefiting, but is the person being exploited by the game and a gang and is just much as a victim as someone who might be the victim of the robbery. And this is just a news article that's talking about particularly serious events where, a child was arrested for murder because they carried out an adult's request. Now, our vacatur standards do not allow for these kind of crimes to be vacated yet. There has been legislation that groups have tried to move for several years now to expand, but I just think it's important that when we're training on these issues, to talk about how broad these criminal acts and how violent they can be. And I like to do that in the context of child soldiers and labor trafficking for forced criminality, because internationally, it's very recognized that children who are forced to commit war crimes are victims of human trafficking, namely labor trafficking. And this isn't really questioned. And these kids have committed some of the most heinous crimes. And I have to ask why kids then within our own borders who are forced to commit some particularly violent crimes are not seen with the same light, given the accepted international practice. And the good news is that although the dynamics I'm asking you to recognize and start filing for vacatur about are complicated, we've seen some really good guidance provided through our child welfare system that I think is a good way of convincing courts that the system and the law recognizes this. So in May of 2024, statewide guidance was issued by our Department of Social Services, and it specifically documents that labor trafficking for forced criminality needs to be properly documented in our child welfare system. And so in this statewide guidance that comes out, the code that's used is involving a child in criminal behavior. And the definition is clear that this code is utilized to identify a child where a third party profits from the child's involvement in performing any illegal act on the third party's behalf. Okay. It gives very clear examples of a wide range of crimes. And I'd like to point out that it says other activities required by a gang, criminal organization. Okay. And finally, it does also highlight that the a child involving a child in criminal behavior can involve a child who traffics others. Okay. And so I feel like this guidance shows that California has finally sort of understood this dynamic and put it in writing. And this is the type of thing that we can use when we go into court and argue for cases that maybe aren't traditionally vacated. And just, I know that there's a lot of controversy around the child welfare system, and I know that I've had lots of clients who lose their kids because of their own victimization, and that the system can be discriminatory. But it is important to understand, especially in the case of child trafficking victims who are facing criminal penalties and or are being placed in the juvenile system, that it could be a strategy to report these kids to DCSS and get them documented as a victim. And that given the statewide training, and at least in LA County where I am, the push that's going on right now to increase identification of labor trafficking for forced criminality, that it might be more effective. So just so you understand how to talk about human trafficking and the child welfare system. So when the abuser or the trafficker is the parent, right? It falls under abuse. So it's squarely in the child welfare system. That's for both labor trafficking or commercial sexual exploitation. However, and this is where it's controversy, if the parent or guardian is not the trafficker, it's explicit right now under our child welfare system that for commercially sexually exploited children or sex trafficking victims, if that would also be a form of child abuse under the neglect category. And then there are those of us who are legal experts who believe that even without the clarifying definition that we have for CSEC, labor trafficking, if it went, especially when it goes on for a long period of time, also would qualify automatically under neglect. What's important to realize is that our child welfare standards say that a child can't be taken away from their parent unless there's like physical or psychological harm. That's a different assessment than the trafficking. And so I always like to be really clear that, in sending a child who might have been trafficked to the child welfare system, again, we can't trust that the system is the best at doing these individualized assessments, but their jobs are to do those individualized assessments and have the child remain with the family with additional support, or remove the child if there is a threat to that safety and health. And again, just from a legal strategy, it's something to think about if we're seeing a lot of kids who are interacting and being placed in the juvenile system when they are clearly victimized. So as lawyers, we're not mandated reportees, or this is clearly your own legal strategy. But if you decide to call the child welfare hotline, I wanted to be really clear that the injury code is 858 exploitation. And there's 3 sub-abuse categories, and you should identify all 3 if all 3 are present. So commercial sexual exploitation, exploiting a child's labor, or involving a child in criminal behavior. And again, you should use that language, and hopefully our hotline workers have been trained or are being trained right now. And again, this is a little bit off our topic for vacatur, but I just think it's really important when we're looking at human trafficking for forced criminality that we think, broadly about our response and how we can change our system's response. And as lawyers, it's important for us to understand this issue because, one, we need to understand the actual criminal liability of our clients. Then we need to understand, are they eligible, or does this criminal activity actually make them legally eligible for additional benefits? And then also we want them to have the right social service support, because we know we can't provide legal services in a back room. And sometimes because people, especially victims of forced criminality, feel complicit in their own um, uh, criminal behaviors, there needs to be a lot of psychosocial education that both helps them understand the abuse, but also prevents them and helps them not become perpetrators in the future. So now I just wanted to do a couple of slides before we get into the nitty-gritty on applying for 236.1, just to say, there's just been, a handful of vacatur cases applied for and granted in LA, which is huge, and across even California, my understanding is there's not a very large number of these cases that have been applied for and or granted yet, but the data shows that the majority of trafficking victims need this supportive services. So in a survey conducted by the National Survivor Network in 2016, 90% of survivors who took the survey reported being arrested or convicted of a crime. Okay. And, the majority did say that the crime they were arrested for was commercial sex, but a close second was 60% reported also being arrested for a wide range of crimes. So what we know is that obviously in the sex trafficking context, a lot of victims are arrested for commercial sex, but though sex trafficking victims are also arrested for a wide range of crimes. And then in the labor trafficking context, they're arrested for a wide range of crimes. The other thing we should be aware of is that in a survey that looked at Oakland and Los Angeles, so it's California specific, for our runaway and homeless youth, 91% of them reported being offered work that was fraudulent or sex trafficking. So, if we're working with particularly vulnerable communities, we have to be asking these questions because it could be that what they're experiencing now isn't trafficking, but they could have been in their past. And so my last slide before we get into talking about 236.14's framework is, I can't encourage you enough to have all your intakes, whether they be in the immigration, civil law, or criminal context, including identification for sex and or labor trafficking. And those questions should and must include very specific questions about criminal acts someone might be forced to commit. Okay. Now I know our intake processes can be hard, so here are my two nitty-gritty questions. If you can only ask two. Did you ever do something illegal or something you thought might be illegal and someone else got all or most of the money? And you just have to answer yes or no. And then if they answer yes, you want to do a full screening, right? Probably at another date. And then the other thing for sex trafficking, have you ever had sex for money and someone else received all of the money? Yes or no? Again, these types of direct questions don't cover the full range of the legal standards, but they present a red flag. If someone's at the point where they can answer yes to these questions, that means they trust you enough and it would be worth it to do a full intake and assessment in these areas. And the last thing I like to say for looking at identification and assessment is, a lot of people are both sex and labor trafficked and labor trafficked for forced criminality. So when you're documenting this, make sure you have all three types of criminalization, like the now statewide child welfare guidance. So we will develop and understand better the dynamics of this crime here in California through your services. Okay, I'm going to stop and see if anyone has any questions on what I just talked about, but because I'm recording, I'm not going to wait for that long. And we're going to launch into the second half of our training, which is on specifically 236.14. Is there any questions? And you can write them in the chat because I have the chat open, or you can put on your camera and ask a question if you're okay with being recorded. Okay, then we will move into the details of Penal Code 236.14. So I start with the slide that says, except for in cases of juvenile records, I believe the best option for all human trafficking victims.
Yeah.
Oh, did someone have a question? Yeah.
Yeah, no worry. They're like they're Tahari, I think.
I just muted the person. I think they were having a different conversation. So So what I was saying is that my own assessment, and you're all lawyers, so you can make your own assessment, is that except in the case of juvenile records, the best option for all human trafficking victims is to file under 236.14. And this is because the statute permits both vacatur and sealing of adult and juvenile arrest records. And you can file when you're still on probation and have outstanding fines and fees at the time of filing. So most of our vacatur standards do not allow for that as well. Vacatur is a much higher standard than some of the other provisions. And the 236.14 human trafficking standard was written with the same framework as a finding of factual innocence. I got a question before the training, so thank you for filling out the survey, that someone directly wanted to know, well, why wouldn't I file for Penal Code 1473.7 over 236.14? So I should say this is not an area of my expertise, but when I compared the two, what I pulled out is that 1473.7 is for convictions only, not arrests. And, if I was an immigration attorney practicing under this administration, I would not, even though arrests should not be considered for immigration purposes, as you know, they can be considered and under the discretionary standard. So I would definitely want to be vacating both convictions and arrests. And then the timing actually is more delayed for Penal Code 1473.7. So you have to be out of judicial custody to apply for it, meaning you can't be on probation. Also, you have this timing standard of reasonable diligence. If you get notice of immigration proceedings. Now, again, as I said, I'm not really a practitioner in this area, but I also looked at sort of what you have to prove under 1473.7. And for me, if you have a trafficking case, it seemed harder to prove than trafficking. But again, you'll also have clients who might not want to reveal information about the trafficking, even though it can be filed confidentially, and or just be really hesitant to talk about their victimization with you. So, again, every assessment should be individualized, and you should be looking at all options, as I know you are. But in general, when I've assessed with those eyes and I have clear indication of victimization, 236.14 has been the best. So what is the 236.14 standard? It allows for a person who has been arrested, convicted, or has a juvenile adjudication of a non-violent offense while they were a trafficking survivor to have the verdict set aside, have the arrest record sealed, and then it doesn't have a time limit for filing. So you can file it whenever. And the elements that must be proven, and the standard is clear and convincing evidence, so slightly lower than beyond a reasonable doubt required in a criminal case, but still a high standard. And interestingly, a higher standard than what's needed for the affirmative defense. So for those of you who are aware, California law also creates a very specific affirmative defense for trafficking victims that public defenders can assert before the conviction, and it is only by a preponderance of the evidence. So I would say if you're a PD on this call, and you can get your client to assert this defense, much better than having to seal and or vacate this record. But I also know that a lot of trafficking survivors just want to get out of custody quickly and will take pleas. So I would have no problem under these standards if I was a public defender or working with a client who just pled guilty because they wanted to filing immediately for the vacatur afterwards. And so, again, the elements that you have to prove are you have to prove it by clear and convincing evidence that they're a victim of trafficking at the time of the nonviolent crime committed. The crime is a direct result of being a trafficking victim, and it's in the best interest of the petitioner and in the interest of justice. And what is that? So we'll talk about what each of those three elements mean and if there's any kind of legal framework around them. But first, I just wanted to show you that the domestic violence and sexual violence vacatur has almost the same standard. You have to be a petitioner of a victim of intimate partner violence or sexual violence at the time of the qualifying crime. The arrest or conviction is the direct result of being a victim of intimate partner violence or sexual violence, and it's in the best interest of justice. So, although this is not my particular area of expertise, I have filed 2 petitions under this standard. The first was for a law student who had been arrested 3 times for domestic violence, and I really believe it was because of her minority status. And so we were able to get the court to grant that vacatur petition. We also had an intersectional case of trafficking and domestic violence where we vacated convictions under the trafficking standard while she was being trafficked, but then when she had escaped, she had gone and lived with a person who had been her purchaser, and that person engaged in domestic violence and blamed her. And so there was an occasion that she was arrested for domestic violence, and we were able to vacate that under the domestic violence standard. So again, you might be using a combination of both. The only difference in the domestic violence standard is that it has to be filed a reasonable time after the person ceased to be a victim of intimate partner violence or sexual violence, or within a reasonable time after the petitioner has sought services. So just something to remember if you're a service provider and assisting that person. Okay, so now looking at the specific definition of the elements that are required under vacatur relief, what you need is that you need an arrest or a conviction while a victim of trafficking. So the reason I spent so much time talking about what a definition of human trafficking was at the beginning of this training is it means that you meet the definition of a victim described in California Penal Code 236.1 A, B, and C. A is the forced labor standard, B is the sex trafficking standard for adults, and C is the sex trafficking standard for minors. So again, the framework we talked about is what you would use to assess. Here again is the California 236.1 standard. But again, I do think the federal standard is easier, and a reminder that PC 236.1 G basically says the legislature finds that the definition of human trafficking is equivalent to the federal definition of severe form of trafficking that I shared with you. So again, using that federal standard is safe under California law. The next thing, and this is, the most disappointing element of the vacatur relief, is that it's limited to non-violent offenses. And so the violent offenses are defined in Penal Code at 667.5C. So that's where you want to see if your criminal charge falls. But examples of what's included in that length Penal Code section is murder, rape, any felony punishable by death or life, robbery, kidnapping. Now, what I want to note specifically, and I kind of alluded to earlier, is that charges for human trafficking, whether it's labor, sex, or trafficking a minor, and pimping are not excluded. They're not defined as violent offenses. So I have successfully been an expert in one case that a PD's office did on vacatur where someone had been convicted and served time as a sex trafficker of minors, and the court vacated that conviction. So again, we know in a lot of cases that victims are arrested and prosecuted alongside their traffickers, or the only ones arrested and prosecuted. So, just because someone has a trafficking conviction should not mean we should not be assessing for victimization. The next standard that we have to think about is committed as a direct result of being a victim, and it's at the time of victimization. So I consider that definition at the time of victimization to sort of clarify what a direct result is. So when I'm trying to establish the standard, what I'm doing is I'm understanding the time period of when someone's trafficked, and they might have multiple traffickers, right? And there might be time periods where there's voluntary engagement in criminal activity and or commercial sex. So we want to understand that, and then you want to pinpoint when the crime is committed. And again, a lot of times survivors don't have a good sense of the timeline. So, it's best if you can get a broad timeline where they're pretty certain, right, that everything was under the control of their trafficker, and then talk about trafficking facts in that timeline, and then because a lot of times they won't remember the explicit details of even when they were arrested or for the crime, placing it in that period where you have good facts of trafficking. But ideally, you'd have like a big picture description of the trafficking, and then you would have a description around the day, right, that arrest happened, of why it was directly related to the trafficking. Because remember, the hardest thing about trafficking cases is they often go on for months, if not years. And so in these vacatur declarations, you want to really narrow your focus, you know, establish the trafficking and how it worked, right? And then if you can, talk about the specific day that the arrest or of that crime happened to make it directly related. Okay. The last thing is that it has to be in the interest of justice. And there's no definition provided for that. But the good thing is for children, it's a presumption, so you don't have to show that. And then for adults, it's usually, just making arguments that this is interfering with your ability to recover, to get employment, to seek housing, to recover mentally, to engage in new relationships has been enough. I haven't seen this be a standard that's, you know, uh, that's difficult to address in this context, because usually once you've described the victimization and the trafficking experience, this type of thing follows. The last thing I want to highlight around the elements are, and because I really want people to be doing this. So even though the language of the statute is really clear that it has to be a direct result of the trafficking to vacate the crime, there's this catch-all provision under 236.14R, and it basically says a court that grants relief pursuant to this section may take additional action as appropriate under the circumstances to carry out the purposes of this section. So I would argue that if a crime is not directly related to the trafficking, but it could be, say, caused by the trafficking. So, for example, someone who is victimized and, sold drugs, but then, 3 years later gets a DUI, and it's after they are out of their trafficking experience, but they can talk truthfully that it was due to the trauma that they turned to drinking and things like that, that you could argue that the court has the power, if they want, to vacate under this standard. And we have a case right now that we're trying that in. I haven't heard of anyone having this Bradder standard granted, but I think, it's going to be at the judge's discretion. So I think we should all be trying to do it in these cases. So then, how do we develop the evidence that we need for these cases? And so there is good guidance in the 236.14 standard for what's can be provided. And it gives a list of what can be considered official documents to the court. And there's guidance in the prosecutor's guide around this that says that because it's explicitly listed, it would be admissible uh, uh, and a likely hearsay exception. But I want to stress that most victims I've worked with simply apply with a detailed declaration from them. And so what does a detailed declaration mean? I don't want to like tell you that you spend so much time going over really difficult things for clients. But for me, a declaration usually is over 10 pages so that it really tells the trafficking story. I know, especially for my criminal defense allies on the call, that can be scary. We don't like to put a lot of things in writing. But in this context, I do want to say that a detailed description of the trafficking. And again, you're writing it in the light most favorable to the client, right? You're not including the facts that aren't legally required to be included, to put forward their best trafficking case. And so, again, we do want to be really careful, especially if there's civil or criminal, other civil, criminal, or immigration proceedings going on, that our declarations are consistent. So we don't have differing facts out there, but it should, like, the main evidence that we have in 236.14 petitions are the declaration. That said, there is a listing of things like a T visa determination, continued presence, access to benefits letters that some survivors will have by the time you're filing for vacatur, and those should definitely be included, because the judge should be taking those seriously, that a third party has already determined this person is a trafficking victim. So when we're drafting the petition, the supporting documents, this is sort of the checklist that I want to make sure. You're going to want to have your motion. We'll talk about the need for stipulations in these cases and the notice of a concurrent filing for multi-jurisdictional petitions. And then the client's sworn declaration. I also like to get copies of the minute orders from each case. Again, because if you're putting in a detailed declaration, you just don't want facts that aren't consistent with the minute orders. For those of you who are service providers like myself, you have to go to the courthouse and pick up the file to get a copy. At least in LA, it's not available online. So I was shocked that I couldn't have access easier than that. I also have found that if I've got close allies with the PD's office, sometimes they can provide those records if you are the attorney of record. And then some clients have corroborating statements, but I want to really stress that not all of them do, and that's part of the trafficking experience, that you really have no one else to vote for you. But on this slide, you can see a list of other potential evidence that you may or may not include, including criminal convictions of the trafficker, other statements from witnesses or other victims from the trafficker, photographs, newsletter articles, and then letters of support and medical records. And then the last thing you want is the proposed order. I know in Los Angeles County, the court has issued the order they want. So they have a template. I don't necessarily think that it's as consistent. So in a lot of counties, you would be submitting and drafting your own order, but you will be receiving templates after receiving this training. So in what's interesting in the 236.14 petition context is that Judicial Council did go through a forms and rulemaking process for 236.14 in 2018. As a result of that process, one committee that dealt with youth created forms that are available in juvenile cases, so JV 748 and JV 749, that you can file for 236.14 petitions. And we have not had to file a lot of these because, as I said, generally the juvenile standard for filing is just as good, so you don't need to go through this process. But in the handful of cases that we have filed, you just file the forms with a declaration from the client. And, I've seen those approved pretty easily. Interestingly, for adults, the Judicial Council declined to issue forms, saying that the process of consolidation was too complicated to use forms for, and we'll talk about what that looks like next. So they only included standard, a Judicial Council standard at Rule 415, which you can find there. Honestly, I don't find it that helpful. It would have been much better for them to issue forms. And I believe that if you can issue forms for juveniles, you should be able to do it for adults equally. But without the forms, what we've seen is that it is sometimes harder, and courts in jurisdictions where people haven't done the filings for even clerks to take the filing. So it does even require some advocacy. So one of the things that we are developing at the Sunita Jane Anti-Trafficking Initiative to assist attorneys like you filing these petitions is template documents. But we know, unfortunately, every court jurisdiction and even individual county might have different requirements. I know we worked on a working group in LA County for years with the court to get them to accept our motion filings and have a standardized practice. That those look very different than what is filed in Orange County and San Diego. And so what I have done is, but I'm not going to have these forms and templates available publicly because I think they are more sensitive than some of the other things that we have placed publicly on our website. So what I'm going to ask you guys to do is, since you're here at this training, just fill out, shoot, I was going to put this in the chat so that you could fill out this form by the end of the training, and this will give grant, then you will get access to our template documents. Again, I want to have this extra barrier for access to our templates because of, I think, that some of the sensitivity of this filing. And just so people know, this will be available for both our public defender, defense counsel, as well as our victim service providers. I believe we're all partners in this area of criminal work for trafficking survivors. But I want those who might have a different opinion than me to be aware of that. Let's see. So I'm trying to get, oh, here it is. That's what I want. So I'm going to put this form in the chat right now. And so again, don't get too distracted from the training, but I know we all wear many, many hats. And so I thought I would make sure that you, during the course of this training, are registered to get the template forms. Because besides a handful of questions, the number one thing people ask me for were templates. So yeah, we'll try to provide them. So then just talking through the procedural rules, and this is where, 236.14 is unique, but it really does recognize, and I should say 236.15 also allows for this, but this stipulation, so it can be decided on the papers, as well as consolidation so that you can have multiple jurisdictions, okay? So basically, specific procedural rules that are within the statute say that the petition must be served on the state or local prosecutorial agency that obtained the conviction or had jurisdiction over the charging decision. I can tell you it's a whole process to figure out who that is and who will pay attention to it. And we'll talk a little bit more about the system we're creating for that next. But you have to serve that on every single DA who's involved. If they do not respond, the statute's clear that the court can deem it unopposed in 45 days and may grant it. Therefore, as long as you can show that you tried, right? You don't have to follow the stipulation process. But again, I believe the majority of us think it's best practice to try to get our DAs as partners in this, the vacatur petitions. Okay, and the thing is, if you don't have the DAs involved, that means if you have cases, and it's very common in trafficking cases to have, 10 arrests or convictions, you'll have to file in all the different jurisdictions, as opposed to if you get them to agree, you can file in just one jurisdiction. So that's the reason. The other thing to note that's in the procedural rules is that the victim petitioner can be excused from appearing on into the 236.14 petition And if they have to appear, they can appear telephonically or by video conference for a compelling reason, because many trafficking survivors have a really awful experience or visual reaction to returning to court. The recommendation is that you don't have them appear for any hearings on this issue unless they absolutely have to, and then definitely ask them if they'd prefer to be by video, unless you think from a legal strategy standpoint it's not good for the case. So when we're looking at that getting the prosecutors engage, again, what we've tried to do is find a point, like in LA County, get a point person. So we're not just reaching out to random prosecutors and DA's offices since we're so big. And and then though, hopefully the prosecutor that you're going to kind of has a general understanding of 236.14, and hopefully they'll be more likely to agree to not to stipulate to not oppose the petition, and so that it can be granted without a hearing. Um, when you're doing this advocacy with prosecutors, as a victim's attorney, I've had, different experiences with different prosecutors. And so I approach them with the understanding that they also support and believe in victims, and so they should be partners in this process. If I can't figure out like the jurisdiction for a certain crime or can't find background on it, especially as an outsider, I'll even ask them to help me figure stuff out. Some will and some won't. But again, I also always keep in mind that information shared with the prosecutor might not be kept confidential. So I have told my clients that I'm sharing information and have their consent. Um, the request that I'm making of the prosecutors is that they sign the stipulation and sign if I'm to consolidate the case. Um, when I send them the request, I generally send the full motion, so I have my best argument and the client's declaration. Um, and then I will follow up in like 2 or 3 days with a telephone call. Um, Now we have, so definitely the consolidation has been agreed to. We've had it for the Los Angeles City Attorney's Office, the Los Angeles DA's office, Ventura County, San Diego, Orange County, and Pasadena, and many others. So it's definitely worth it to try to get them to consolidate. But I think the balance is how long do you spend trying to do it versus filing the same petition in different jurisdictions. So. Um, the other thing to think about is practical considerations for where you file if you have them consolidated. So interestingly, for a period of time, we found that filing in Orange County was more friendly than in Los Angeles. So we would ask to consolidate and then file in Orange County. Again, those are different kinds of strategies that I'm hoping when we have a listserv on this, we can talk about those types of things. I already kind of talked about this, but I just wanted to point out that sometimes your advocacy begins at the filing window because we've had lots of court clerks reject filings made by mail, and or even when we've appeared in person, we have to ask for a supervisor. So our recommendation, unless your jurisdiction is really familiar with these petitions, is to file in person, and also, make sure that you speak to the clerk and actually get on the calendar within the period that they're required to hear it. And then what we do is just call the judge's chambers a week or two before the filing to then check in to make sure that they have the case. The other thing is when you're filing in person, this is the court rule for filing confidentiality. These cases should and can be filed that way. So I'm not going to walk through it, but just follow the California Code that's a process. And I have a link from CAST that shows the cover sheet that you should put on your envelope. So I wanted to mention that in addition to the template documents, to access them, I also want us to collaborate to create institutional knowledge about judges, prosecutors, public defenders' offices, and the different templates. And so I've created, and you'll get this link after and periodically when you hear from me, a table of all the contacts that we have worked with on the vacatur petitions, and then and also a form that if you have templates from your own county or jurisdiction that you're willing to share, or information with a DA or PD or judge about the filing process in your jurisdiction, that you would share. So hopefully that will be a ongoing resource that we can all build together, because one of the hardest things in these cases is figuring out the complexities of the different jurisdictions. And the other thing that has come up with the 236.14 filings are, just note that sometimes the conviction is vacated under a different standard, but the arrest record is not sealed. I believe it's best to get the arrest record sealed under 236.14. And so if the conviction, you can still see it, I would say also try to get the conviction fully removed. And you see that sometimes if the conviction's been expunged under a different standard. And then just a reminder that, you do need to pay financial restitution to a victim for under 236.14. But if it's not, if it's fines or fees that were ordered to the court or for other reasons, you don't have to pay them. We've even had courts refund victims like a significant amount of money once they grant the vacatur order. So that is a good thing. For hearings in this case, just note that, like, if you haven't done these before and your jurisdiction isn't familiar with it, we found that the initial court date usually turns out to be a jurisdictional hearing, just educational hearing, and not the merits hearing that you thought you were showing up for, so that the judge would grant it. And that's just because so many judges or if the DA's office didn't respond to you, aren't familiar with this process. And just note, if you are certain this is not a merits hearing, then the client definitely doesn't need to appear. For the merits hearing, I've only been part of one contested hearing, and that was in that sex trafficking of a minor's vacatur conviction, where the victim did take the stand, as well as two experts to build her case. Um, uh, uh, um, I know the DA's office is now contesting cases more on procedural reasons in LA County, so we'll have more updates on how those cases go. And I just, if you're not having responsive district attorneys, I do think the best thing is to file, and then they have the window to take a position on the case and proceed to the hearing, because this is the best way to educate the judge about the dynamics of trafficking, and the DA's office if they're not being responsive. Now, unfortunately, once you have the vacatur issue ordered, your job is not done. There's a lot to do to make sure then that really essential relief actually benefits the client. So suggestions for what to do after the fact is, if your client is on probation, ensure that probation receives a copy of the order granting the relief. That order automatically terminates the probation, but obviously you want to provide it to the probation officer, because most people don't know about it. You also, at the hearing, make sure you ask the clerk for certified copies for every jurisdiction where the relief was granted. So if you had 7 or 8, and then mail them directly to the clerks in those departments. Again, the court that did this should be doing that, but this is your way of ensuring, right, that these cases are come off, the files are destroyed as they should be. And then the other thing to do is to follow up with the financial department of the court if the court grants the request for reimbursement for fines and fees. And then finally, you can also notify any of the DAs or prosecuting agencies that were involved and send them the order, so that they can destroy those records too. So I think most of you are familiar with expungement versus vacatur, but the results of the vacatur is the sealing and destruction of all the records from the Department of Justice, court records. You get your money back except for the restitution. I see a question of someone asking for reimbursement of fines and fees for successful. And so I will share that if you fill out the template, so you are able to get template documents, and I will share a specific one where we asked for that and it was granted. Um, and then it also should clear it for fingerprints and bookings, police arrest records, probation, and parole records. And so sealing and vacatur are really different than expungement. Um, so the other thing we do after you do all of that is that we keep the cases open usually for 6 months. And then after 6 months, we do another background check and follow up with the Department of Justice. We have found that DOJ, because there's so few of these that are granted, has struggled with actually removing these cases. And the guide that I'll reference you at the end has really good background on how to make sure that happens if you're having a problem. So again, all of you are more familiar with advisement after records are vacated, but just a reminder that you cannot ask about the conviction if you're an employer, and you should be able to tell your client that after they receive this order, they can check no on any form. Um, and again, even though arrests can't generally be considered for employment purposes, the arrest should be completely removed as well for those narrow exemptions they are. The thing that a lot of people are excited to hear for trafficking victims is if they had a duty to register as a sex offender under whatever crime they were convicted of, that should also be removed. And that is generally like, for a pimping and pandering offense, is the only one, because the other ones our assessment is, are likely violent offenses that you couldn't vacate. So unfortunately, trafficking victims will not just have vacatur issues in California, and they'll have them under multiple state provisions, given the dynamics of trafficking. So there is a project called Freedom Network USA that focuses on survivor reentry, and they have a network of pro bono and attorneys across the country who can help survivors vacate records in other states. So again, if your background check reveals, as many will, that's something to start that process with as soon as you're working on the California state vacatur. And then, you are all experienced practitioners with vulnerable clients, and I'm sure you all have taken trauma-informed lawyering skills building classes. So I only have one slide in this training on engaging with clients in this very difficult process. But my recommendation is if you don't have that background, that you should spend time on taking trauma-informed lawyer skills. We do have some suggestions that we developed at Loyola. If you're interested, you can email me and I'll share them on the listserv. Otherwise, my general rule of thumbs in these cases are manage expectations. Like there are like these dates that are part of the vacatur process, and it's by statute, but I find they never take the length that they say they will. So, doubling the time so that the client's expectation of when something like this will happen is set accordingly because of the newness of the provision, I think is really important, unless you're working in a jurisdiction where you're pretty certain of the timeline. Because I always find it's better to have clients be excited that it happened earlier than they thought it would, as opposed to worry that it's taking longer. And then the other basic question is, ask them how involved they want to be in this process. I think for most clients, what they want is for you to ask them as little questions as possible and to be, not reminded of their traumatic past as much as possible, but for some, they really want to be engaged. And it is the first time maybe they're sharing certain things, and it is feel empowering. So just understanding what this process means to them and engaging them as little or as much as you can, depending on their needs. And the last thing I'm going to talk about, and I'm doing really good on time because I'm sorry this is a 2-hour training, but we're covering a lot, is for those of you who aren't legal service practitioners who don't generally practice with human trafficking, something you should know and be aware is if you identify someone as a human trafficking victim for this vacatur process, they're eligible for a lot more benefits. So I'm talking to you, defense attorneys. They're 100, if they qualify for a vacatur, they're almost 100% if they're an immigrant eligible for a T visa. And that also means not just for them, but generally their family members. If they're a child to their parents, it's a huge benefit, even in this awful climate. Um, it's much more dangerous to be undocumented, so definitely refer these cases to experienced immigration attorneys. And if you've got the vacatur for the criminal convictions, that's going to be a huge help in, in this day and age immigration process. I used to tell people, oh, in trafficking cases, there's such a wide immigration exception. It's not a problem, but now we all must be more cautious. The other thing I want you to know, and I'm hoping everyone as part of their vacatur practice will do this, is that a trafficking victim who has been trafficked over 2 years is generally eligible for $20,000 in victim compensation benefits. Once you know how to do the application, it takes about a half an hour and it takes about 9 months to get the result. So if you do this for a trafficking victim, as you do the intake for the great vacatur relief, you will not only be able to vacate your client's conviction, but you will be handing them a check for $20,000, which I can't tell you is so important in rebuilding someone's life. The other thing is obviously if you identify them as a trafficking victim, there is a network of specialized service providers across the state. And so you should be thinking about making those specialized referrals. But what I'm going to talk to you really quickly about is how do you get this $20,000 for your client? Okay, so this falls under AB 629, lost income benefits for human trafficking survivors. This is through the Victim Compensation Board. Basically, the Victim Compensation Fund in California is for any crime victim of a violent crime, and human trafficking is one of those listed crimes. And what's important for you guys to know is that unlike a lot of the crimes where you have to have a police report for human trafficking victims, you do not. You do have to have a specialized declaration from a human trafficking caseworker, but no law enforcement report at all is needed. I want to stress that. So there should be no barrier to applying for this benefit for a trafficking victim. And then the other thing I want to stress is that you often have to show injury as a result of a crime. But in the trafficking cases per se, if you're documented as trafficked, that that means you suffered a physical injury, so that's all you have to show. And so who can help survivors apply to these applications? Attorneys like ourselves. And honestly, most of the time this is in the realm of social workers do this, but I actually feel like attorneys should be doing this more because the Victim Compensation Fund is really stingy in how it gives its benefits and doesn't follow its own legal standards, and that's where lawyers need to help. And so how do you know your client's eligible? Like, so clear things that's going to make someone ineligible for the $20,000 if the crime didn't happen in California. Now, you can have trafficking victims whose crime happened in many states, but it just needs to happen in part in California to be eligible. Okay, so that's the first thing. The other thing is you generally have to apply for this within 7 years. There is an exception for the 7 years, but it's more complicated. So, reach out for TA if you have that. But if someone is under 21 when the crime happens, they actually have 7 years, or under 18 when the crime happens, they actually have 7 years after their 21st birthday, so even longer. So I find most victims that we're working on vacatur with fall within that time period. The other thing you should know is that it's clear for crime victim benefits funds that immigration status doesn't matter. So you can be documented or undocumented. And then there's also interesting provisions that say that membership or association with a gang or as a suspected gang member does not mean that you're not eligible. And I'm talking to you about lost income benefits, which is a specific benefit only for trafficking survivors. But um, there are a list of benefits that when you do the application, you can apply for. For most victims, we recommend they just check the box for mental health services, which means they can get mental health services at any time in the future and have that mental health service provider reimbursed. So it just makes sense to do that. And then there's different standards for establishing eligibility for things like relocation and others. So I can say that these are not easy standards to meet. I actually think the lost income standard is one of the easiest because you don't have to have receipts or show certain types of things. But again, I wanted you to be aware that I'm mostly focused on one type of benefit. Um, and so this is a relatively new law that started in 2020. And I want to be clear, it's available for sex and labor trafficking survivors and trafficking survivors whose labor or service was forced criminality. It does not distinguish, right? Because it's not compensating them for the illegal activity, it's compensating them for the time that you spent in the trafficking that you could have been working at a legitimate employment. So it's compensating you for minimum wage, okay? And basically how it works is that you can get for each year, you can get up to $10,000. And it's basically a calculation of $420 a week, which is minimum wage, okay? Each week up to a certain amount, but it caps out. And then after the first year, you can get an additional $10,000, but it caps out at $20,000. So if you're trafficked for 8 years, you don't get any more money. And what you're looking for is a victim who has worked in general 40 hours or more a week, because again, it's based on a minimum wage calculation for their trafficker. And if they work, 80 hours, it doesn't matter. You're looking at weekly work. And you're also making sure that they don't receive, and because some do receive money from their traffickers for payment that's over $420 a week. Because if you have that payment, then you got paid too much. And so this benefit wouldn't help you. And then the last thing I just want to highlight is that we have gotten documentation from VCP to say that tips do not count toward being paid wages. And so if you ask clients, did you get any money or benefit while you're in your trafficking except for tips? And if they say, no, I didn't get any money or I already got tips, then you're doing good because they can get the full amount. And if you ask it correctly, that's generally, especially in the sex trafficking context, what they'll provide. And then the other thing is, in the minor sex trafficking cases where the minor keeps the money because they're engaging in commercial sex and it's trafficking per se, even though it's just a purchaser, generally those individuals will not be involved for this benefit because they'll have made too much money from the exploitation. So those are just common rules of thumb. And so again, it's a really easy application. I'm not going to go over it, but there's an online application, but because the online forms are so kind of like they don't really fit with what you need to submit for the lost income, because it's not new, but it's not effectively implemented. We always recommend that you just apply by paper. And we do offer a 1-hour training, and these templates are publicly available on our website. So I'll make sure when I send out an email to highlight this, but I just really wanted you all to think about if you apply for Vacatur, you should definitely be applying for this $20,000 for clients. And now, just in conclusion, I mentioned a couple of resources. So CAST has a great resource guide on filing 236.14. Free to Thrive also did a great guide that's available on our website. So you can go there. We have a website that just went up yesterday that's now dedicated to the human trafficking vacatur. And if for some reason you don't register to get the template forms today on that website, so you don't have to type in the whole link to, is that registration. We're also asking you if you want to be included on our website as a potential resource for someone who's filing to provide information. And if you have, uh, if you want to be part of our working group. Um, Also, just know that SGI has a wide range of policy priorities that we work on, designated by our 8 different butterflies. So this one falls under our access to victim services butterfly, but we have many forward-looking preventative policy requests that we would appreciate your support on. Also, because labor trafficking for forced criminality is an emerging area and idea in a lot of counties and districts, I've created this list of resources. Some are ones developed by SJI and some are ones that I found super helpful. We're going to skip the the uh, activity because I think you're all tired by now, so I won't put you into breakout rooms. But I did just want to share with you the table and the form that I created for, let's go back to this. So I talked about how I want us to work together collaboratively to get the templates and the forms for all jurisdictions, because obviously, because of where we're located, we're mainly filing in Los Angeles and San Diego and in Southern California area. And so uh, you can see what I've started here. So this is the list that I've created now. You can see that it tells you if it's an information about a judge or a court, a district attorney, a city attorney, or a public defender. So you can sort by that. And then it also lets you sort by district. And what I tried to do is just put the biggest area in that. Because again, it could be that for the smaller districts, there might not be anyone who's entered information in, so you can kind of find someone close and at least reach out. Or you can also search, and this one has like all the like I think I put in like 30 different jurisdictions. So we can gradually compile information for all of them. Then you put in the name of the contact, their title, email, phone, and then just like information about them. And then if you do have templates for, the judge or the court, that this is where you would insert them. And I haven't done that yet, but we will put in some of ours into this template. But I wanted people to experiment with this form first before I kind of spent more time inputting information to it. But I just wanted you to see what we're looking for. And again, everyone has access to view this form and copy and paste data from it. But where you would input your form is in this template form, where you're just required to input your email as so we know who it is, and then the date so we can sort of see how recent it is. And then again, this is where you can select what the information's about, the specific jurisdiction, name, and then right here is where you really put the meat in, or you're putting in your template documents. So again, it's pretty short. I would love if anyone has resources and contacts for you in the next 2 or 3 days to just take the like 15 minutes. Actually, it's the weekend. So today or Monday or Tuesday, just take the 15 minutes to share your institutional knowledge that I think will help us create a real network for doing these petitions across the state. I can't tell you how long we spend like each time trying to figure out for these unique cases, but I do think I think there is 32 people who registered for this call. So if we all did that, we really will create the network that will help us streamline the cases. So with that, I would just like to thank you for your time today. I know 2 hours on Zoom is not no one's favorite, and take any questions. So I see one. Someone says, are there any tips for more friendly jurisdictions to file? In this case, the jurisdictions are LA and San Bernardino. Hmm. Uh, I don't know between those two which is better right now. I do know there's been extensive delays in Los Angeles County because of the change in the new DA and a transition in the team. So right now, there's been no petitions granted, I want to say, in 10 months, and the DA's office is contesting the form that had been created by the old judge, because we have a new judge who oversees these petitions. So, San Bernardino, if it doesn't have those issues, might be your best bet. But again, I feel like the listserv will be a good way for us to kind of have those kind of discussions. So, yeah. Any other questions? Okay, well, I will give you 3 minutes back of your very important Friday. Thank you again so much for joining us.